In this episode, we discuss a major policy rollback by the Environment Ministry, which exempts most coal-based thermal power plants from installing sulphur emission control systems. We also look at how the Lok Sabha functioned for only 18 minutes yesterday amid opposition protests. But we begin today with the Bombay High Court's acquittal of all accused in the 2006 Mumbai train blasts case. Hi, I'm Ichha Sharma, and you're listening to Three Things, the Indian Express news show. On Monday, the Bombay High Court acquitted all 12 accused in the 2006 Mumbai train blasts case, which killed 189 people and injured over 800. In doing so, the court set aside a special court verdict that had earlier sentenced 5 of the accused to death and the remaining 7 to life imprisonment. A special bench of Justices Anil S. Kilor and Shyam C. Chandak found significant flaws in the submissions made by the anti-terrorism squad that it utterly failed to establish offences beyond reasonable doubt against the accused on each count. What's especially noteworthy is that the accused had already spent over 18 years in jail. One of the men sentenced to death died of COVID-19 in prison in 2021. He too was acquitted by the High Court. To understand how the case fell apart and what the court's verdict highlighted, my colleague Shashank Bhargava speaks to the Indian Express's National Legal Editor Apurva Vishwanathwe.
Apurva, it was the 11th of July 2006 that a series of bombs exploded in Mumbai on 7 western suburban coaches. It killed a total of 189 commuters, and eventually a total of 13 people were accused and later convicted in the matter. And all these 13 people have now been acquitted. Could you just sketch the broad outlines of this case for us before we talk about its details?
So, the trial for the 7/11 blasts concluded in 2015, and a special court, which was designated under the Maharashtra Control of Organised Crimes Act, which is MACOCA, it's a very stringent anti-terror law, had sentenced 5 accused to death and given life term to 7. So this was the status of the trial, and subsequently, because any death sentence has to be confirmed by the High Court necessarily, there was a process of appeal in the High Court, and it actually took quite a while for the High Court to hear this matter. The last 6 months, it was heard by a special bench, and on Monday you had a verdict in which the High Court acquitted all 12 accused and said that the prosecution was not able to prove any of the charges against them.
And while the Maharashtra government had approached the Bombay High Court for the confirmation of the death penalty granted to these 5 men, there were also appeals filed by those who were convicted to challenge the order of the special court. So talk about what the Bombay High Court looked at during this appeal. What all was it considering?
So the appeal in the Bombay High Court, the last 6 months, is actually a very fine reading of the evidence. The trial court would have looked at this enormous evidence that the prosecution would have collected against all the accused, right? So the High Court has to see whether the trial court appreciated this evidence in the right way, which means that whether they read it right or not. So these were also very lengthy hearings, almost about 70 hearings that happened in the High Court, in which the High Court finds glaring procedural gaps and also several faults in how the trial court looked at this evidence.
Right, and Apurva, now let's break down the reason why the court acquitted these 12 men. Now we understand that the special court had relied a lot on confessional statements, many of which the Bombay High Court rejected. So firstly, how common is it for courts to accept such confessional statements? And what does this verdict say about them?
So, before we get into the specifics of the case, a little bit of primer on how confessional statements actually work in terror laws, right? So the MACOCA, as we discussed, like the UAPA, in fact, even ED, there is a significant relaxation in evidentiary status, which means they're all alternate criminal law systems. They're not your regular criminal law. Say if, you're tried under the IPC for murder or the Bharatiya Nyaya Sanhita for murder, there's a different evidence process compared to how you're treated under these special anti-terror laws. This relaxation is given because, terror is a very stringent offense and the state needs that kind of an apparatus to deal with these things. For one, the relaxation is that in ordinary criminal law, confessions made to the police are not admissible as evidence in court.
Right, because the idea is that the police could torture you, get a statement out of you, and then use it against you.
Right. There's a presumption that the police can, use custodial torture as a method to extract confessions. And in India, this is not new at all or surprising at all. So, which is why you have to give a statement before the magistrate, and only that will be accepted as evidence in a court of law. But in these terror laws, a statement given to police is admissible as evidence. So how these confessions are obtained becomes really crucial in determining whether they are valid or not.
So when in this case confessions were given to the police, why has the Bombay High Court rejected them?
So you look at the circumstances, right? So in July, the incident happens. By September, the accused are picked up and their statements are recorded, which is these confessional statements are recorded. And each of the accused has stayed in police custody for different periods of time. Say some for 79 days, some for a month, varying lengths. And all of them, the day they go to judicial custody, which is from police custody, you go to a jail, where you are no longer under the watch of the ATS, for example, in this case. They all retract their statement, which means at the first available opportunity away from the police, they all say, we never signed that statement. So that's very important, the timing of it. The second thing is, of course, the statements themselves, right? And here there are a number of cues to pick up for the court. And when I say cues, this is essentially evidence, right? Let's start with the basic one. Several statements are identical to each other. In fact, the court notes, and this is a 617-page judgment, but it's written very lucidly. So anyone's interested in how this case, has unfolded should pick up the judgment and read it. There are questions posed by the DCP level officer who is investigating a Makoka case. Under the Makoka, it's not as if the IO or any subordinate policeman can investigate, right? It is a DCP level senior officer who is asking questions to these accused. And when they record their statements, the questions are identical, the answers are identical. In fact, down to the ellipses after sentences, they are identical. In fact, the court puts them in, pictures in the judgment and highlights the enlarged portions of these ellipses. It seems impossible that each of the accused took those pauses, had the same expressions. The information they provide might be identical, but the manner in which they do the language and the expressions being identical, that's where the court thinks that there is an alternate theory that is possible, which is that these confessions were obtained under duress.
And can't someone argue that, for example, if Apurva and Shashank are accused, sure, they both tell us what happened in their own words, but just to avoid paperwork and to save time, the police just put down the same confession.
Yeah, so very valid, right? So this question was put to a cop while he was being cross-examined, and the court records that there was no format that was used. These were statements being recorded by different DCPs on different dates in different places, but they somehow seem to be all identical. Another argument that the defense brings up is that these are confessions, right? So which means people are voluntarily giving information, or, even if they were sort of pushed to give information, that they are giving you a tale of how they committed the crime, plotted it. So the defense points out that these statements are full of information about how the accused traveled to Pakistan, where they obtained training, who in Pakistan they were dealing with, and, all those details in the background. But about the crime itself, they don't have detailed information, which means how they committed the crime, which they clearly should have a first-hand knowledge of. Those details are missing. So let me give you one case which the judgment points out, right? Accused number 6, Alam Sheikh, has confessed that 15 kgs of RDX was brought to his residence, right? So that part he's confessed to. But he does not have any details about how much RDX was used for the blasts, what happened to the remaining, or how did they dispose it? None of those details they're able to give. So the defense is essentially saying that somehow all the confessions are only giving information which the ATS already knows, right? They're not revelatory in the sense that, for example, if, you committed a crime, you will tell me, this is how I picked up the knife, then I went to this person's house, I knocked on the door at 2 a.m. and, I stabbed him 5 times. All these details, right? This is exactly what somebody with first-hand information will be sharing.
Right, maybe I saw someone on my way, or something I noticed about the house, or something I recall about the victim.
Right. And then how did you dispose the weapon and things like that. Whereas in these confessions, the counsels were showing the court that it's replete with the broad details of a conspiracy, a Pakistani connection and those things. But how the crime itself was sort of planned and committed, those are missing. So which also is to push the theory that they didn't actually give these confessions.
And in this case, the special court also relied on eyewitnesses, right? There were these taxi drivers who drove these men to the Churchgate station. There were witnesses who apparently saw these men planting bombs in trains. What has the court found out about these eyewitness accounts?
So again, there is something called a test identification parade that happens while investigating a crime like any crime, which means if there are eyewitnesses present, they will be taken. They will be, you might have seen this in movies. There are 4 or 5 similar looking men.
Yeah, they'll be in a lineup.
Correct. They're in a lineup and you're supposed to identify who you think is the perpetrator, right? So in this case, the court noted that it was the taxi drivers who participate in the test identification parade. This happens almost 100 days after, the incident. And these drivers point out to people and say that, yes, this person did take a ride on my taxi, right? So there's seemingly nothing to trigger their memory after such a long period of time. I mean, 100 days is a long time to remember a face for a taxi driver who probably sees dozens of customers every day, right? On the other hand, the defense pointed out that there were other eyewitnesses, people in the train who said that we saw a person plant something in the train, right? They were not called to the TIP. So was it a case of the prosecution picking eyewitnesses who would give them a favorable choice there? Or was it a case of actually genuinely exploring who was the perpetrator, right? Because remember, when the TIP was happening, the ATS had already said that they had cracked the case, right? They had picked up these men. There was a case that was already building. So then the court says, there is doubts on the credibility of the assessment of these eyewitnesses. Having said that, the issue about the eyewitnesses, those are circumstantial evidences, right? They are not in itself evidence, which means, even if you picked a guy on the lineup, that itself is not enough to convict him, right? Or if you pick the wrong guy, that in itself is not grounds to acquit that guy. These are all parts of a big loop that are put together, placed together. So statements of eyewitnesses, other circumstantial evidence, what you recover from people's homes, right? They accuse themselves. So in this case, there are, in each of the recoveries, there's a map of either the suburban railway line of Mumbai or a map of Southeast Asia or some such thing, right? Are these adequate to show that there was participation? There's also a whole trove of other evidence, including their passports and things like that. But it is to be seen how all these things connect to the actual crime, which is what the prosecution should be proving. And these are where the court finds holes in. But this is a circumstantial part. The most significant part of the court ruling is actually the question of whether there was any application of mind in invoking Makoka.
You mean the court questioned whether Makoka should have been used in the first place?
Yes, in a sense, yes. So what happens when you invoke a law like Makoka or UAPA, given that they give the state such sweeping wide powers, right? It effectively tilts the balance against the accused. So in those cases, as a procedural safeguard, and this is very key because that is one of the very few procedural safeguards for these laws, you require a prior sanction, which means in the case of Makoka, it is a very high-ranking police official who has to look at the material, satisfy himself that this is a case fit for invoking a stringent law like Makoka, right? And this also happens in, say, corruption cases, where you need a higher authority to tell you that this is fit. It's just to rule out arbitrariness. It is so that no random thanedar can invoke Makoka against you, but that the state has really thought this through and decided that this is a fit case to use a draconian law against you, right? And it's justifiable. So that satisfaction of the sanctioning authority is very important. In this case, it turns out that the prior approval was granted based on a 2.5-page proposal with no supporting documents. So the sanctioning authority had a phone conversation with one of the police officials, and that's who in turn spoke to one of the accused when he was getting the confessional statement, and that's how the sanction was granted. So the court says that, the sanctioning authority did not have enough material before him to satisfy himself for this. So thereby the sanction is vitiated, that it was not granted with any kind of application of mind. So if the sanction goes, the prosecution under that goes. That's sort of the linchpin of what holds the case together.
Oh, so the confessions, for example, don't hold any meaning if Makoka was not sanctioned properly.
It's more complex than that, because it's not as if the court is letting all the accused go for a procedural lapse only. There is a question of sanction and prior approval, but the court also looks into the whole gamut of evidence. Like I said, the confessional statements, right? And there is a whole bunch of allegations about custodial torture. And these are some very chilling accounts by the accused themselves. In fact, they submitted handwritten notes to the court detailing the alleged torture by the police. In many cases, there are medical records which attest to this kind of torture. And they're very granular and chilling details. For a court to actually reproduce all of them in the judgment and point this out. And it's not as if that's taken as the gospel truth. Again, in any criminal trial, you have to place every statement in its context and relevant time, right? The court is saying there are pronounced periods of incarceration, then Makoka is invoked, and suddenly there are confessional statements, and the accused retract them at the first available opportunity. And this is each one of them. All 11 confessional statements, all of them were retracted the day they moved to judicial custody. And then the nature of the confessional statements itself, like, they were identical and they were not very revelatory and those things. So it's not as if it's only the procedural ground or only the, substantive ground. It's both. Essentially, these anti-terror laws like Makoka, like UAPA, they really do give the state a free hand. And there are lower standards of evidence that the state has to kind of bring to these cases, which is, like I said, confessional statements are accepted as evidence. So if the state in this case could not even prove it to that standard, that is what the court is looking at essentially.
And this does raise some serious questions about the police and the ATS. Because one imagines that after a terror attack like this, there is a lot of pressure to show that justice has been delivered. But this case, for example, proves that they did not go about doing this in the right way. And there were just so many loopholes in their investigation.
In fact, the problems with this investigation actually surfaced not yesterday when the judgment came out, but actually way back in 2008. Because in 2008, the Mumbai crime branch, the Maharashtra crime branch, had picked up 5 men. They claimed that they were from the Indian Mujahideen, and these 5 members were involved in a host of terror cases, including 7/11. Which means actually in 2006, the ATS picked up these 13 men and said they were responsible for 7/11. And 2 years later, another department of the same state is saying, no, but these guys were actually responsible. Of course, they didn't file charges on the 5 men in 2008. That sort of was left at that stage. But what happens is that kind of pokes the first holes in this ATS theory, right? How can 2 sets of Indian Mujahideen guys be responsible for the same attack? And then now, in fact, Justice Kilor, who wrote the judgment, starts with a very disquieting prologue. And he says this, that, punishing the actual perpetrator of a crime is a concrete and essential step towards curbing criminal activities, upholding the rule of law, and ensuring the safety and security of citizens. But creating a false appearance of having solved a case by presenting that the accused have been brought to justice gives a misleading sense of resolution. He goes on to say that this deceptive closure undermines public trust and falsely reassures society, while in reality, the true threat remains at large. And this really sums up what this whole trial has been about. Because if these 13 didn't do it, who did it? There are 189 people killed. And for their families, people who've lost their loved ones, a father, a son, a daughter, and a mother, there is no sense of closure. 20 years later, they don't know who were really responsible for the deaths of their loved ones.
And next, we turn to a decision that has raised concerns amongst several environmentalists. Earlier this month, the Environment Ministry exempted the majority of India's coal-based thermal plants from installing systems that are designed to remove sulphur dioxide emissions, which are a key contributor to air pollution.
So, coal is one of the biggest fuel that is used for producing energy in India. Almost over 50% of India's energy requirements are met through coal-fired thermal power plants.
That's the Indian Express's Nikhil Ghanekar, who reports on environment for the paper.
When the coal is used in these power plants, the combustion process leads to emission of various gases. Sulphur dioxide is one of those harmful gases, and it is one of the major causes of air pollution across our cities and towns.
Nikhil tells us that these emissions are not just concentrated near the plants themselves. They actually spread beyond district boundaries, adding to what's called transboundary pollution. He also explains that sulphur dioxide, or SO2, plays a big role in forming what are known as secondary pollutants. That's when harmful gases in the air mix with other substances, creating things like sulfate and fine particles, what we often hear referred to as PM 2.5.
Now, regarding the impacts on human health, it naturally, since it's a harmful gas, it adversely affects our health and primarily our respiratory organs. It causes respiratory irritation, respiratory diseases, and also can worsen the existing respiratory illnesses. It is particularly harmful for vulnerable groups such as pregnant women, children, and people of the elderly group.
So, to bring in new emission control norms, in 2015, the Ministry of Environment, Forest and Climate Change made it mandatory for all thermal power plants across India to install flue gas desulfurization units, or FGD units.
Now, flue gases are basically the gases which are emitted into the atmosphere when the combustion process takes place of coal. It's not like a small device, but it's basically like a setup within the power plant, at the site of the power plant, where it is passed through certain chemical processes and liquids to clean those emissions and remove the sulfur pollutants. And then whatever is left is released into the atmosphere after the removal process. That is essentially the job of the work that a flue gas desulfurization device does.
However, Nikhil tells us that its implementation has faced consistent resistance. In fact, the first compliance deadline of December 2017 was missed across the board.
So when the Environment Ministry brought about these new norms, there were no stringent norms as such or specific norms regarding the control of emissions from coal-fired power plants. So that is why they were welcomed in the first place when the ministry notified these emission norms. However, what happened is that the first deadline, which was 2017 December, the Power Ministry as well as the power sector at large, they were not confident of meeting these deadlines, and they also held a lot of negotiations with the Environment Ministry vis-a-vis compliance of these norms. They said that installing the necessary devices would be expensive. Initially, they had said that a lot of the parts of these devices would require importing of material from abroad, and that would raise the cost of what is passed down to the consumer as the final product, which is the electricity tariff. So they gave a host of reasons for not complying.
And so, to resolve the standoff, a task force was established to recommend a phased installation plan, categorizing power plants based on their pollution impact.
So they said that those which are situated around Delhi NCR region, which is, as we all know, a very highly polluted area, and sulfur studies have shown that it contributes almost 14 to 17% of formation of PM 2.5 or particulate 2.5 pollution is contributed because of sulfur, of which power plants is one of the biggest contributors. So they said that let's put these kind of plants in category A, which are within a certain kilometer radius range of Delhi NCR. Then category P plants were those which were around critically polluted areas. These are areas which are specifically demarcated as critically polluted by the government of India, specifically the Environment Ministry. And category C plants are those which are not in either of these two categories, two brackets. These were the categories created and specific deadlines were given as per the category. And for our listeners, we have to point this out very categorically that a government study, specifically the Niti Ayog's commission study, NEERI, National Environmental Engineering Research Institute, had carried out. This study specifies how many plants are basically in the different brackets.
And so based on this study, about 11% of the plants were placed in category A. These are the ones in and around the Delhi NCR region. Another 11% were put in category B, which includes areas that are critically polluted. But the vast majority, around 78%, were placed in category C, meaning they are not in either of those zones. And now with the latest changes to the norms, it's these category C plants that have been fully exempted from installing FGD units.
So the Power Ministry and the Central Electricity Authority, they held very hard negotiations with the Environment Ministry. One could qualify this as very aggressive lobbying for the sake of, from their point of view, saying that this would put a huge burden on thermal power plants, which are already stressed because of certain factors, some of them being the issues of the cost of operating them. But by and large, the government's recent decision was based on 3 studies which were done by the Indian Institute of Technology, 3 separate studies, one by the Indian Institute of Technology, Delhi, the National Environmental Engineering Research Institute, Nagpur, and the National Institute of Advanced Studies, Bangalore. Now, what they studied was essentially, number one, the impact of power plants on sulphur emissions. They looked at whether the installation of FGDs was actually helping in cutting pollution or not. And thirdly, they looked at what are the solutions and what are the recommendations or prescriptions for the time ahead.
And now these studies seem to suggest, and this has also been the government's reasoning, that FGD units are not necessary for all power plants.
And why did they say that? They studied the sulphur emissions around power plants and they found that the emission concentration was not as high as it was thought to be by a lot of people. And it was well within the national ambient air quality standards. That is number one. So they said that instead of focusing on sulphur dioxide emissions and the secondary pollutants that it caused, let's focus on the pollution of particulate matter.
Now, some of these studies also shifted focus to electrostatic precipitators, or ESPs, as a way to control particulate matter rather than relying on sulfur-specific devices like FGDs. ESPs are also pollution control devices, but they mainly help reduce fly ash and particulate matter, not gases like sulfur dioxide.
And on the back of these studies and recommendations of the Principal Scientific Advisor, the Central Pollution Control Board and the Ministry of Environment and Forest and Climate Change, they brought out this new notification giving relaxations to Category C plants, exempting them completely from installing the FGD devices. Category B plants, they said that will be taking up on a case-to-case basis for this mandate. And Category A plants, which we mentioned earlier, were around Delhi NCR and a specific radius around Delhi NCR, they would still have to comply with this mandate by 2027 end.
This rollback, however, has prompted strong criticism from environmental watchdogs. They have pointed to a lack of policy consistency, arguing that the same government which introduced rigorous emission standards in 2015 has now diluted its own commitment.
So, like we mentioned earlier, a lot of these decisions over the years, ranging from deadline extensions as well as the exemptions that have been given now, have been a result and outcome of the hard negotiations that were carried out by the Ministry of Power and the lobbying that was done by different associations of the power sector. So, the fundamental criticism here is that when the Environment Ministry had taken a stance on, and which was welcomed in 2015, of putting out stringent emissions, why was there no political stability on and policy stability rather on seeing through the implementation of these norms? Because there were certain studies that were done in 2015 also by IIT Delhi with regards to the contribution of sulfur dioxide to overall pollution in the vicinity of power plants and also beyond the boundaries of the districts in which these power plants are located. So that was the main criticism, that the science that has been used by the Office of the Principal Scientific Advisor and these 3 different institutions they are by and large saying the same thing, that FGDs are not required. So it has essentially created a lot of skepticism around what was the intention of commissioning these studies in the first place. Secondly, questions still persist on why the role of sulfur dioxide in creation of secondary pollutants has been downplayed, because the contribution is there for everyone to see in past studies also, which formed the basis of this mandate in the first place. So these have been some of the criticisms leveled by people working in the sector of bodies such as Center for Science and Environment, a non-profit organization, is one of the people who have been leading in criticism against this policy.
And in the end, we turn to the ongoing monsoon session of Parliament. A day after the resignation of Vice President Jagdeep Dhankhar, who served as the ex officio chairman of the upper house, proceedings in the Lok Sabha were disrupted for the second day in a row. This happened due to opposition parties protesting against the special intensive revision of electoral rolls in Bihar. As a result, the House functioned for just 18 minutes across 3 brief sittings before it was adjourned for the day. Opposition MPs from the Congress, Samajwadi Party, Rashtriya Janata Dal, Dravidi Munnetra, Kazhagam, left parties and Trinamool Congress entered the well of the House holding placards with slogans like SIR equals death of democracy, SIR stealing Indian rights, and quit SIR. They also chanted slogans including Tanashahi nahi chalegi, which loosely translates to autocracy will not be tolerated.
Please be seated. Please. नहीं, please. सदन का समय को आप उपयोग कीजिए. नहीं, please. ऐसे, please be seated. Please. सदन चलने दीजिए. सदन का समय सबका है.
During the question hour, Agriculture Minister Shivraj Singh Chauhan appealed to the opposition to allow the session to proceed, saying that the questions scheduled were about farmers and rural issues. In response, Speaker Om Birla said that the House is a space for discussion, not sloganeering, and that he would not allow placards in the chamber. He then adjourned the House till noon. When the House reconvened, Minister of State for Parliamentary Affairs Arjun Ram Meghwal and Parliamentary Affairs Minister Kiran Rijiju both said that the government was ready to discuss any issue as long as it was raised through proper parliamentary procedures. Rijiju condemned what he described as repeated disruptions through placards and said such actions wasted public funds. Meanwhile, 7 pending bills are set for consideration and 8 new bills are up for introduction and passage. Notable among them are the Manipur Goods and Services Tax Amendment Bill 2025, which will replace an ordinance, the Taxation Laws Amendment Bill 2025, and the Indian Institutes of Management Amendment Bill 2025. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by Shashank, Bhargava and me, Ichha Sharma. If you like the show, do subscribe to us wherever you get your podcast. You can also recommend it to someone you think may like it, with a friend or in your family. This is the best way for people to get to know about us. You can also tweet us at Express Podcast or write to us at podcast@indianexpress.com.